In this session, we are going to see about the transfer of property as defined by Section 5 of the Transfer of Property Act. What is the transfer of property? The property has not been defined in the Transfer of Property Act. It defines immovable property and movable property as a property other than the immovable property. Property is not defined. Section 5 of the Transfer of Property Act defines the transfer of property as an act by which a living person conveys a property in present or in future to one or more living person. That is, a living person conveys a property to one or more living persons or to himself and one or more other living persons. This is transfer of property. A living person conveys a property to another person. If you see the things, what are the essential things? There should be a transfer by a living person to another living person. Both those persons should be a living person. A transfer to a unborn child is not permitted. But Section 13 permits that with some condition. That is, prior interest should be created. Some interest should be created. The property should be in their temporary charge. When the person comes into existence, then the transfer of property will take place. That is Section 30. The Section 5 says it should be between a living person to another living person. Next condition, conveys a property in present or in future. That word in present or in future relates to conveyance, not to the future or not to the property. The conveyance may be in present or conveyance may be in future. For example, in the case of a sale, the conveyance is in present. That is, immediately the property is conveyed to the other person. In the case of gift, this can be postponed. For example, a person may write a gift deed in favor of her daughter and with a condition, this will take effect only at the time of her marriage. That means conveyance is not present, it is future. Conveyance may be present or future. Another condition, the property should be present, not a future property. The person who is having a property can alone transfer it. He cannot transfer a future property. The living person includes the companies and other associations or body corporate. Next, we will see what are the kinds of transfer. There are 5 kinds of transfers. One is sale. Sale is immediate. For conservation, the property is transferred. The conveyance is done. Property rights are transferred. Absolute right transferred for conservation, sale. Next, mortgage. The person is giving some right to the other person. In case I am not paying the money, you take the property, realize your debt. Yes, some security is created. Some rights are given. In some mortgages, possession is given. Some mortgages, possession is not given. Next is lease. Lease is also a transfer of right. Some rights are transferred. That is, possession is given. A right to enjoy the property is given. Next is exchange. Exchange is one property is exchanged for another property. For example, 2 brothers, it got 2 houses in the partition. Subsequently, they may decide we will exchange our property. They may, for this house, he may give another mango garden or a coconut garden, or one house for another house. That is exchange of property. He is giving this property and the other person is giving his property. In exchange, instead of money, it is only property to property. That is exchange. Next is a gift. Gift is without consideration. A person is giving the property to another person. This is a transfer. There are some case laws, they say something is not a conveyance. For example, partition is not a conveyance because the persons were having already interest in the property. For example, A and B are the brothers. They were holding their family property, 10 cents of land. Now on partition each will have 5 cents. Previously they were having 1/2 right over the property. Now he will have absolute right over part of it. There is no conveyance of the right. They were already having conveyance. Now already having right over the property. Now they have a identify specific property. Another thing, relinquishment is not a transfer of property. For example, there may be 5 persons. One person may be well-to-do, other 4 may not be. So this person may relinquish his right over the property so that the other 4 can share the property. This is also not a transfer of property. Easement is not a transfer of property. Easement is a right to pathway or right to take water. That all things is not a transfer of property. In the same way, will is also not a transfer of property. There is no conveyance because the definition says it is a conveyance of property by one living person to another person. In the case of will, there is no no living person. So this is also considered not as a transfer of property. In the same way, family settlement also, there may not be a transfer of property because everybody will have a right over the property. Now they are sharing their rights. Next we will move on to the section 6. Section 6 says what can be transferred. Property of any kind may be transferred. So any kind of property may be transferred, but there is a condition, subject to a condition. They say except as otherwise provided by the Act or any other law for the time being in force. And this section has some exceptions. Except these things you transfer anything. First is section 6A. This is regarding spes successionis. That is, you cannot transfer a right which you are going to acquire. For example, a son of a king cannot transfer his right. I will be the king after my father's death. You give me money and I give you that right. That is not possible. A person cannot say my father is having this much property, after his death I will be the person who will be holding the entire asset. So you give me money, I will give you a right over the property. That is not possible. That is, the chance of a heir apparent of succeeding to an estate. A person's, that is, son of a father who is holding an estate, who is holding some assets, he cannot transfer his right. Another one, the chance of relation obtaining legacy on the death of a kinsman. Some relative is there, he will give me some property, I am transferring it. It is also not possible. Another thing, any other mere possibility of like nature cannot be transferred. Any possibility of getting there. For example, seeing that definition of immovable property, we saw that benefit arising out of land is also a immovable property, like right to catch the fish. If a person put a net in the lake and transferring the right, I have put a net in the lake, I am transferring the right, whatever fish is there you can take. That is also not permitted. So 3 things are not permitted. That is, heir apparent succeeding to an estate. That is, father's property, a son who will be getting that. Next, chance of relation obtaining legacy on the death of a kinsman, some relative's death, I will get a money. That is also not possible. Anything mere possibility of like nature is also not possible. For example, father transfers property to his wife. Father died, wife is holding. Then it should come to the son. If the property has to come to the son, there are 2 things. He should alive when the mother dies. Another condition, mother may sell the property also in between. So that is not permitted. It is heir apparent succeeding to an estate. You don't have a right, so you cannot sell it. That is the main principle. Because you don't have a property, you have a chance of acquiring a property. That cannot be permitted. Chance of acquiring the property rights cannot be transferred. Next is section B, right to re-entry. In some cases there may be a right to re-entry. For example, a person might have given a property on lease. with some condition. If you are doing this, there is a right to re-entry. For example, if you are cutting any tree in my mango garden, then the lease will be terminated. I will come inside. There is a right of re-entry, taking back the rights. This cannot be transferred. Right of re-entry cannot be transferred according to section 6b. Next is section C. Easement cannot be transferred. For example, right of pathway, right to draw water from a well, that cannot be transferred. 6D, restricted interest cannot be transferred. For example, there may be an old lady, a relative of a big relative of a person who has so many houses. He may give one house to that lady. So long as you are alive, you stay here. It is personally to enjoy the property. She cannot transfer that right of enjoyment to the another person. Since she is an old lady without no means, then she was very poor, so this person gave the house to stay, personally to stay. That lady cannot transfer her right to stay in the house to another person. That is restricted interest. Her interest is to personally to stay in that house. Next is a maintenance. A right to future maintenance cannot be transferred. For example, a widow or a divorcee. Divorcee got a order from the court for monthly maintenance. His husband has to pay 10,000 rupees per month. Now, she is in urgent need of money for some medical expenses, 1 lakh rupees required. She cannot go to another person and say that I will be getting 10,000 rupees per month for the next 12 months. I am transferring my right to receive to you. That is not possible. That right to receive future maintenance cannot be transferred according to section 6DD. Section 6E, mere right to sue cannot be transferred. There is a breach of contract, damages to be claimed through the court. A person can go file a suit, damages can be claimed. But if he thinks it will take more time, 3 or 4 years, I want urgently money, he cannot go to another person and transfer his right to sue to the other person. He himself has to file a suit. He cannot transfer that right to the another person. Next is a public office. Section 6F. Public office cannot be transferred. In the olden days, there were some public offices. In the Jamindar days and other days, even long back, some village munsips. Now we are having village administrative offices. Previously, there were village munsips. They were having it as a hereditary. They were fathers and all these things. That type of public offices were existence at that time. That cannot be transferred. Next is pensions. Pensions, stipends, these are things that cannot be transferred. Next, section 7. What to do, who can do, that it says. Every person competent to contract entitled to transfer of property or authorized to dispose of property. Either wholly or in part, he can absolutely or conditionally transfer. What says, every person competent to contract. The transferor should be competent to contract. Transferring need not be. For example, your grandfather can transfer his property to his grandson who is of 10 years old. Now, the 10 years old boy is not having the capacity to enter into contract, but still, he can be a transferee. What will happen? His father will be the guardian. He will receive on behalf of the minor. Transferee need not have the capacity to contract, but the transferor should have the capacity to the contract. He should be entitled to the transferable property. The property should be his own, or he should have been authorized to sell the property, authorized to dispose the transferable property. By power of attorney, he might have got a right over the property to transfer the property to someone. For example, he might have got a power of attorney to sell the property. So his own property, or he has authorization to transfer the property. He can transfer wholly or in part. He can sell the entire thing or he can sell part. He can sell absolutely or conditionally. He can transfer absolutely or conditionally. For example, sale absolutely. If he is selling it, it is absolutely. If the person is giving, in our earlier example, if the person is giving the property to his daughter with a condition that she can take it only after the marriage, then it is a conditional. In the circumstances, extent and manner allowed prescribed by law for the time being. That is according to some, if there is some other law, he should abide by the rules of that law also. So, section 7 says, a person capacity to contract, he should have the right over the property, or he should have the authorization to transfer the property. He can transfer it absolutely or conditionally. He can transfer partly or in full. Now, next section 8. Section 8 of the transfer of property provides that unless different intention is expressed or necessarily implied, a transfer of property passes forthwith the transferee all the interest which the transferor is then capable of passing. That is, whatever the right he has, that is being transferred to the other person. All the rights of the transferor is transferred. What he is capable of transferring, capable of passing the property. For example, if a person is selling the house, it includes the doors, windows, lock, all these things. That is, entire thing will be transferred. Now, we have to make a comparison between 6A and section 43. What 6A we are saying? A person who don't have a right over that now, a person who will be getting something after his father's death cannot transfer the right. Father's property which he is going to acquire after his death cannot be transferred because he don't have a right over the property. But there is another section 43. It is called what is that? Transfer by unauthorized person. There is a provision for transfer by an unauthorized person. For example, A is the father and B is the son. B is holding two properties, A is having one property. Actually, both three are father's property. Father transferred two properties to his son and retained one property. Up to his death, he will be holding it. What the son has done, he has sold all the three properties. Fraudulently, he has sold all the three properties. He has a right over only the two properties. But he has sold the property which was in the possession of his father. Now, it is a fraudulent sale, unauthorized. The person don't have the right over the property. In such a case, if the father dies and the property goes to the person who has sold it, then that person, the person who has purchased it, can claim that you are telling that you are having the right over the property. At that time you did not have that. Now you are having the right. You transfer it to me. That is section 33. He can take the property, the person transfer, because unauthorizedly, fraudulently, he has sold the property. There must be a fraudulent or erroneous representation by the owner. Owner should have done this erroneous representation or fraudulent. In this case, what we are told that three properties, he is telling that all the three are mine, but it is one is with his father. Erroneous or fraudulent representation. Transfer by the wrong owner. He is not the owner. Father is the owner. He sold the property of the father also. The transfer must be for a consideration. If the transferor acquires subsequent interest in the property, then the transferee can claim the interest. He can claim to transfer the property to him. Now we have to compare 6A and 43. 6A restricts no transfer. But 43, even if there is no transfer, no right at that time of transfer, the person was not having right. But still 43 permits. Why? That is, in this case, Jamma Masjid versus K. Devaya, Supreme Court has explained this. Because section 66A is a substantial law. It says you should not do. That is why it is not permitting. But section 43 is a rule of estoppel which is one of evidence. It is a rule of estoppel. What is a rule of estoppel? That is, if one person says something and allows the other person to believe that it is correct, he cannot subsequently say, no, that is not correct. He cannot subsequently correct it. Now what this person has done, he told that I am having 3 properties. It was a fraud. But the other person believed it and purchased it. When the property comes to him, as he told earlier, he should sell it to the other person. He should transfer it to the other person. That is estoppel. He was telling something which was not correct. Now he should go by the words he has already spoken. That is rule of estoppel, which is one of evidence. Now in the next session we will see some more topic.